from the president and his oath. He takes an oath of office. The cabinet secretaries, the members of National Assembly, the members of county assemblies, the speakers of the county assembly, one of the things they do is to take a Bible or a Quran and swear that, we will, implement in our code of conduct, in all our reflections, we will reflect the law in our offices. So I think when it comes to bridging the requirements of the law, it is important for each and every leader in this country, to reflect on the oath of office they took, regardless of any political factions one is coming from. But beyond that, we must insist on this set that the sanctity of law is something that you cannot replace by a manifesto, by agenda, or by the sectarian and personal interest somebody pursue. Because when one do that, then it becomes a point of chaos. Yeah. And we've said, and again we cannot really overemphasize much, that it's gonna be chaotic because now we are facing few months to election. And each and every leader in this country would want to prove, that they are the ones that are in charge of different positions in different offices. And this shoulder rubbing that we are seeing is just the beginning, because there are members of National Assembly that would want to go to the Senate seat. There are members of senators that would want to go for governorship. And once a governor is asked to come into the committee of the Senate, any senator that would want to run for that position would really rub shoulder. We saw that in Kakamega recently. Right. The members of National Assembly in the committee as well. So I think it's important that as we go to this, we also become alive to the realities of the contemporary political issues that we are facing in this country. Can we merge the ideal and reality, then we can be able to know really what is required in the political discourse.
All right. Mheshimiwa, Orengo in, Orengo out, Orengo in. Discuss.
Rida, this is surely where I have been talking about a double edge. Double edge is that Orengo happened to be one of the panels that actually that were under the task force, which was appointed between the Senate and the National Assembly to give a report on the way forward. Both become housed to take on a matter to do with the BBI, and Orengo and his team of lawyers is one of those who signed that particular report on his dissatisfaction on unconstitutionalities of the BBI. And he cited the issue to do with the constituency determinations. And today, he's in the front line as a defender of the same BBI. Then this is what we call a double edge. Because here, Orengo is defending the whole BBI to say as it is, when he did poke it at the report level. Then he tells us there is what we call hypocrisy. And in this particular case, I would say, well and good, because at that particular point, we thought even the relationship between him and his boss is winning. But actually, we later found that actually it was a game either. I cannot be able to say, but it was either a political arithmetic or something else. In matter to do with the BBI, reader, in my own position, I will tell you, and I repeat again here. Here, we have deliberated about issue to do with what we call laxity to implement what we call the laws we make or policies we make. It tells that in our custody, we have a big bunch of laws that actually are not doing anything, but they are kept under the rockers, doing nothing, because implementers have no business with it. In the BBI, I can ask you a simple question. Have we implemented every other lot of the current constitutional order? And what we are lacking today is only what the BBI is talking about. To me, this is a hypocrisy of the highest order. And I will tell you, the only reason and game inside this BBI is not two ways, it's succession battle. And this is just a vessel being created purposely to make sure that it gives a group a smooth ride or a soft landing of 2022 election.
Hold it right there, Mheshimiwa.
And I can tell you without any shy that the whole BBI interest is in the element of executive and nothing else. The rest are carrots.
But even if we were to overlook that last bit, we agree that we don't necessarily have to wait for us to implement a constitution to the maximum for us to make changes. That even for us to attain the 2010 constitution.
But I can tell you, Rita, in one way, can I ask you a simple question? If really we are serious enough in our amendments, really, have we already exercised all and everything that actually is being envisaged by this constitution, so that we can know where else the hinges are? But here we are just analyzing, and just to do what I can say, I would say it is a teething issue, because we have not dealt with totally. Because here, I think the constitution we could have first and foremost implemented to the whole. After that, we give it at this time over at least a duration of 15 years of time. Then we analyze it all. We do it's what we call audit. After that audit, then we'll be able to know what and what and what and what. But here we are in rush. We do this amendment because we have found it difficult. I will tell you for sure, and this take it to the bank, that the authors and propellers of this particular draft are well known. When we move to the new constitution, who are the pushers of the new constitution? They are well known. What they never materialized at that point is that they never got that particular fruit they were fighting for. And therefore, this is just another vessel to make sure that actually we find another angle of achieving their ideas. It is not the interest of Kenyans.
Okay,
Yes.
as you respond to that, Honorable,
yes.
Honorable Wahome, as you respond to that,
Yes.
do you suppose the having Orengo, as one of the lawyers who debate on this and represents the appellates, is going to be a disadvantage for them somehow?
Not even a disadvantage. I think it is a very bad sign for the children of this country. Those children who are at the level of understanding what happens in the Senate. And the Senate is very closely watched by students, especially those who are undertaking history in secondary schools. And they saw how passionate James Orengo was in declaring that the Constitutional Amendment Bill 2020 was unconstitutional. And then the same children are watching him in court speaking at cross purposes, actually countermanding what he said at the Senate. I don't think that is good for even families in this country, and for the future generations who should trust in us, what we say. I don't think we shall have to go to cultivate that trust from our children and even the people of this country, that politicians can be trusted with what they say. And Orengo, being a senior counsel, he is my senior and we respect him, but on this one, clearly he has dragged all of us who are politicians and lawyers through the
Is it too
march.
early to judge him, because he would have gone through the prospects of the same and maybe viewed it differently, interpreted some of the clauses that he had pinpointed differently, and therefore we probably should allow him time to argue this case, and then maybe we'd understand where he comes from?
I think Orengo did not only have the Damascus effect after talking to Baba,
Okay.
and therefore any changes definitely they are not purely from his conscience,
All right.
or is from his very appreciating the larger interest of this country. And what I'm saying is that clearly a person of Orengo's studying as a senior counsel, also whom as young lawyers in this country and even his juniors in the practice have been looking up to, I think this is very sad and it is very unfortunate.
Okay.
The other issue I would want to say is that I don't want to get into the mind of the judges, what they would decide on this issue. But what I would want to say is that when I looked at the appearance yesterday, and when they were discussing the doctrine of the basic doctrine on the constitution, on the structure of the constitution. And I think they were kind of agreeing with what the High Court said. And if what they said yesterday, it is taken up by the respondents, then I can tell you that it will be very difficult for the appearance. But what I know and what I can, this is a high stakes case. And I expect that the Rusa in the Court of Appeal will be heading to the Supreme Court. In all, what we are saying that, like myself, And as I would say that I'm very disoriented. I'm trying to follow what is happening there, that we would want a better law in this country to regulate what we do and how we engage socially, politically, and economically. But when I find that basic things cannot be followed with the law that we have there today, like now, and I continue going back to Nyandarua, that the people of Nyandarua, they know what is the law, but somebody does not respect that law, and they can see that he seems to have the instruments of power supporting him, despite the express demonstration of impunity. We remain disoriented, helpless, and I can tell you, reader, we are not looking at the constitutional reforms, or even statutory reforms. We are waiting for the second Tuesday of August 2022, when the people of Nyandarua will speak and remove impunity, and then we can talk about reforms.
Well, it begins at home. Maybe you're wondering why Mheshimiwa is so much focused on the Nyandarua factor and all that, but it is
because that is where the law is failing.
Okay.
That's you know.
That you must start with Damascus.
Yes. Linda, I have a really contrary opinion to what my colleagues are mentioning.
Okay.
The Honorable James Orengo at the floor of the Senate disqualified the process of constitutional amendment.
Okay.
And he was clear on one aspect, that when it comes to questioning the amendment at the National Assembly and at the Senate, using a popular initiative, that was a role that the two arms of legislature could not do, because it was basically unpopular opinion. Orengo did not entirely quash the amendment of the Constitution through the popular initiative. I think both him and Senior Counsel Otiende Amolo had reservations on the touch of the Senate and on the touch of the National Assembly. On amending, some sections of that proposed bill. That is when they said that the role of the two, arms of the legislature should not be ceremonial, and in effect, they can participate on unconstitutional constitutional amendment. I think that was clearly
tell us about Orengo and the matters to do with the creation of constituencies, because to him that was establishing the block.
Yes. And I think that was one aspect that he did. The other aspect that he mentioned,
let us work together. At that point, let us understand his change of heart, because did he want to persuade the judiciary or this appeal court to purge out that section of constituency
delimitation,
and then they approve the rest? Or is he waiting for the whole document?
Okay.
I do not know the intentions of James Orengo. I cannot get into his mind. And I agree. That was what I wanted to correct my colleagues, because he wasn't really quashing the entire
the procedure.
And he mentioned some sections of involvement of the two legislators. Now, I have been also very vocal in terms of the constitutional amendment process, and I think I agree with what Speaker said, that let us not discuss what is in the court, but again we can discuss what really it is in the matter of public interest. All these, what the High Court ruled on 13th of May, is it May of June, what the High Court actually ruled, and you could see one was touching on public participation, the sanctity of public participation, the role of IEBC, the involvement of the president. And I think in the last panel we questioned if the president would involve himself in a constitutional amendment as a private citizen of Republic of Kenya or as President Uhuru Kenyatta. And this is left for the interpretation of the appellate court. I think we questioned this thing last time in this panel, and it's found its way yesterday in the discussion. So this is my own put into the whole discussion. One, I foresee a situation, and the court pronounced itself yesterday about the requirements of IEBC does it have numbers? Does it have the required threshold to carry out an election? The question I keep on asking, that ever since we saw the exit of the commissioners, IEBC has conducted a number of by-elections. Does that disqualify the entire elections that were conducted by IEBC?
Right.
And if that is so, are those people who were in position, including UDA's Msambweni, is he out of question? Should he return back to the elections? So everybody that is questioning
but in that aspect,
that one should be. Yes, Jimmy, why can't you allow me to suggest?
Allow him to counter briefly.
In that particular aspect, I would just want to urge you that in fact the courts cannot act on a matter that has not reached to their desk. So in all the previous elections that this particular commission has been participated on,
if nobody goes
they have never been challenged, it is not the duty of the court to go to hunt.
But then again, all right.
But you see, Jimmy, you're also trying to strike a double standard that you're talking about. One of the things that we are mentioning, that if you question the electoral management body, it's conducted these elections. Do you disabuse the outcome of those elections?
And someone will go to bring, someone will raise that in court.
That is one thing that I'm also saying.
Yeah.
And lastly, because we do not want to interpret what the judges would see, what is provided, what then is public participation?
Okay.
This has been a matter that we've been asking severally here and in other platforms. Is public participation a merely a payment of the signature? Is public participation a mere turnout, of an electoral in terms of even just overseeing a process that is political or constitutional? I urge the Court of Appeal to clearly revisit what is then the standardized version of public participation. Is it civic engagement? Is it an entire public participation? Because then, if that is not interpreted, then it will come back again. Even in the processes that we are foreseeing, to still haunt the question of public participation. I think, lastly, the participation of Senior Counsel James Orengo.
The working constitution.
Did you remember the case that Philomena Mwilu had?
Yes.
That also I think it was Nurdin Haji that questioned if Orengo would represent, Philomena Mwilu, because he's an interested
person of interest.
There's a conflict of interest,
yes.
And I think the ruling was
the
given.
president has questioned that.
The president has questioned that also. So it is very important. Again, I do not want to have a subjective view on this, but it's also important, to question: do we have members of the National Assembly who are also representing their own law firms and their own interest parties at the corridors of justice? I think these are matters that
okay, Rita, I think we needed to talk about this issue.
Yes.
In the case of Mwilu, is that Orengo had not commented on that issue at all. It is only that the DPP was objecting to him representing Mwilu because he is a senator, and they are supposed to somehow oversight the judiciary. But here is a case where Orengo rendered himself very clearly that the constitutional amendment bill, as long as it included the limitations of boundaries for parliamentary seats, then it was unconstitutional.
Okay.
You will have a very Herculean task to be able to convince anybody that now that constitutional amendment bill 2020 has now gained constitutional legitimacy. And therefore, I don't think we need to really dwell on that one very much. The other issue is that when he spoke in the Senate, his position was that the parliament is not there as a rubber stamp. That parliament would go and interrogate the constitutional amendment bill 2020. He again abandoned that approach. So at the end of the day, when it came to this BBI issue, Orengo, nobody knows where he stands. He is here, he is there, he is everywhere.
Okay.
And therefore, and it is going to be very embarrassing for him. The Third Way Alliance have gotten orders to be allowed to submit the report of the Hansard. And Orengo is supposed to be in this matter. The report of the Hansard is the countermanding anything that he will be saying in the Court of Appeal. because that is not what he said when he was at the Senate. Therefore, I think this is an issue that will even kill some careers and also be a very big dent on some people's names when history is written. The respect, obviously, I had for Senior Counsel Orengo, from what happened in the Parliament and what is happening in the court, definitely. It has been diminished to a great deal.
Right.
And just to add the final remarks on that, I would say our expectation from that particular bench is that one should tell us if, or out of the 22 number of charge clauses or orders given,
how will they?
Yes, if 1 or 2 or 3 are not going to be overturned by this appeal, is the BBI going to survive? Is it really? Yes, because surely there can be areas of, yes, like where they recommended the president can be taken to court. I am sure that can be struck out, and some few. But out of the 22, if there is maybe 5 or 10 orders that will still remain, do we still hope that actually will be a survival of this baby?
Catch 22 as we close. Dan.
I am optimistic that the Court of Appeal would provide, a judgment that is, content and that is really cogent as we proceed with minors, taking political interest and, trying to play political game, and I agree with it. But one of the things that I also foresee is that ruling in itself would, provide a benchmark at which, in which some of these cases would be dealt with in finality. And the things that I've just told you, that, in finality, the court must really help Kenyans to redefine some of these terms that we've mentioned, public participation, what is that threshold? Is it okay still that some senior counsel would still play as, at the legislature, but also play within the judiciary? So I think it's important that should be given in finality in this ruling. But then it also will tell, this also comes back to the position of, the president of the judiciary, because this is an indictment to her performance. We are also foreseeing a situation where, what if the court rules otherwise, and people proceed to the Supreme Court and that is dealt with finality? Would that really have an image in the relationship between, the causal relationship between judiciary and the executive? So I think it's a situation that, it's very interesting.
It's very interesting to watch, and indeed we are watching. 30 seconds.
Thank you, Leader. And as I sign off, I would want to say that the Court of Appeal, in the eyes of most lawyers, they call it the graveyard of jurisprudence. That is where that jurisprudence in this country is killed. I believe they would want by this case to redeem themselves. And this case is so important for this country that I believe they will put their best foot forward as they reach a decision on this matter. And there is nothing that the clearest pointer to this is that the president of the Supreme Court, judge we really respect, Justice Daniel Musinga, indicated that they will not require less than 30 days to do the judgment on this appeal. We know that the Supreme Court has been able to hear and decide on a presidential petition within 14 days, hearing and deciding on it. The Court of Appeal wants to have 4 days to hear the appeal and then 30 days at least to deliver a judgment. This, I believe, it will be a watershed that even generations to come and outside our lifetimes, that they want to put down a judgment that will be remembered forever.
Timelines.
But I believe that there will be a split judgment. I'm looking for a 4-2. I will not want 4-3. Okay. I don't want to say on which side. Finally, Leader, is to assure the people of Nyandarua that there's an uncertainty that is prevailing there. The impunity and the crowd of corruption is coming to an end. They remain calm.
All right. Timelines.
Reader, in my 30 seconds, what I would just want to emphasize is that as a country, this country is a great country, and Kenya as a country is not migrating. Kenya will remain. leaders will come and go, and they will leave this country behind. There is nothing which is so much hurting that we must be forced that without BBI, Kenya cannot prosper, Kenya cannot move ahead. I would want to emphasize that we can move to elections as usual, as normal, without BBI, and the BBI cannot be purported as the bus which must make us stagnant. We must not change our calendars whatsoever, because if BBI is for Kenyans, Kenyans must not be ruined their previous fruits that they have already achieved. And therefore, no single person or people should start on front and try to say that because the BBI vessel is not on place, then we are going to do what we call postmortem of elections until this baby is alive. I would say the battle for the BBI to proceed, but the calendars of the country must proceed as they are constitutionally.
All right. Well, Miss,
I think it's important to...
We're closing.
Yeah. Even if the ruling is otherwise for the proponents of the bill, it is important to acknowledge that there are some elements within the Constitution Amendment Bill 2020 that is important for this country, that outlines that we should have a peaceful, secure, and accountable elections. That is important that we have, expedite matters of justice, have a timeline. But on the timeline, I am for certain sure that, there's going to be no possibility of referendum. Should this, because the Constitution provides that, if you must have it, then, it can't be, less than a year to the general elections. So I think it's also important to watch the outcome. But as a country, regardless of the outcome of this ruling, we are a constitution-mandated country. The foundation of this country is laid on constitutionalism.
Well, maybe they would adjust and probably have that conversation that was presented in Parliament, that you can as well hold the referendum alongside the general election. Is one conversation. I mean, it's all about timelines, and we'll be following keenly just to make sure that you are updated and at least bring on board analysts that can as well help us decipher more on these crucial matters. Thank you so much, gentlemen. Daniel Rogo, governance expert, Honorable Jimmy Gakuya, Embakasi North Member of Parliament, and lastly, Honorable Ndegwa Wahome, Chair County Assemblies Forum. We close it at that. We get to matters relationship after this break.